This is Alfredo Hernandez doing my podcast assignment for my Communications Law and Ethics class. Today the topic is label and some of the cases that affected label. Not all of them, but some of them that I found really interesting. So first off, what is label? It is a published false statement that is damaging a person's reputation, basically a written defamation, like how slander is spoken defamation. Okay, so one of the first important cases that happened in the United States was New York Times v. Sullivan, 1964. And the background of this case is that followers of MLK published a full-page advertisement in New York Times. The ad was about how civil rights activists were victims of unforeseen waves of terror and listed various actions that the Alabama authorities had taken against them. Well, the problem with the ad was they had some errors in it, basically, with one example being how many times MLK was arrested. Now, Montgomery City Commissioner L.B. Sullivan saw this, and he was responsible of supervising the police department, so he filed a label suit against Times. Now, the significance and the finding of this case is that the court ruled with Times, since Times didn't actually mean for those errors, and they were simply just mistakes. Now, this is significant because they brought up a term that will be used multiple times in different other cases, which was actual malice. And what is actual malice? Well, the idea is that a publisher published a story with false information to damage somebody's reputation, and they still publish it while knowing it's false. That's how actual malice is defined and used to find if certain cases that were for label or against label. Now, one big case here is Hustler Magazine versus Falwell, which happened in 1988. A lead story in the November 1983 issue of Hustler Magazine featured a parody of an advertisement modeled after an actual ad campaign claiming that Falwell, a fundamentalist minister and political leader, had a drunken incestuous relationship with his mother in an outhouse. Well, it's not hard to say that Falwell didn't take kindly to that. He sued them to recover damages for label, invasion of privacy, and unintentional infliction of emotional distress for the poor man. Well, the court ruled that a public figure, such as Jerry Falwell, may not recover for the intentional infliction of emotional distress without showing that the offending publication contained false statements of fact, which was made with actual malice. Basically, the meaning is that the publisher knew that this information was false, aka a parody, but didn't advertise it as being the truth. Basically, making the significance of this case is that a parody is protected by the First Amendment, along as the publisher fully well knows it's false and doesn't advertise it as the truth. It protects it. Now, another good case for label laws is Killen v. Gulliver Comp Court, which happened in 1998. So Brian Kaito Killen was a witness of the O.J. Simpson's murder trial, who sued a tabloid newspaper called Globe Communications for label for their published cover headline titled "Cops Think Kaito Did It." So the issue was that Globe falsely suggested that the police believed that Kaito was somehow involved in the murders of the O.J. Simpson case. Well, the finding was that the court ruled in favor of Killian, basically Kaito, stating that the headline could be interpreted as defamation, and that Kaito was able to present significant evidence to show that the Globe may have published the headline while not regarding the truth. I mean, they might have known it was false and still publish it. So the significance of this case was that it considered defamation of the headline, even if the story itself didn't support it. As long as if someone can perceive it, it is defamation, and there's this possibility that the magazine published it while not really caring about the truth of the information that they were publishing. So those were some of the cases that affected the label laws of the United States. There are other cases here that can affected the label laws of the United States, like how Milkovich v. Lorien Journal Co., which basically the significance of that case was that the state cannot impose strict liability because that would run foul of the First Amendment. This holding differs significantly from most other common laws jurisdictions, which had a strictly liability of defamation. Some other cases were like Barrett v. Rosenell that does not permit a website to be sued for label that was written by other parties and stuff. Well, there's definitely going to be moments where in the future label laws are going to evolve because many people will find a way to try to discredit other people they don't dislike. Those were some of the cases that I found interesting and were able to say properly to show how these cases were affected label laws here in the United States. Thank you for listening and enjoy this small podcast, and I hope you have a nice day. Bye.